Good morning. Please be seated.
Amen.
This is the time and date set for oral argument in cause number CV20-0607, Nackard v. Nackard. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal. Also, we've read the briefs. We have discussed this case in conference. We're familiar with the facts. Please take that into account during your presentation. At this point, I'm going to ask you guys to argue from your podiums, just so we don't cross-contaminate one another. So, please proceed.
Good morning, and please the court. My name is Elizabeth Feldman, and I represent the wife in this case, who is the appellant, Julie Nackard, who happens to be present in the courtroom. She's the one that's a little bit older than most of the law clerks, just a wee bit. And this is sort of, can I pull this? Do you care?
Yep, you can move it. Be comfortable.
Well.
As comfortable as you can.
So if it pleases the court, this is a case about financial fairness and equity in a long-term marriage. We understand that both of the parties received a substantial amount of assets in this case. They split the community, which was a nice estate. But husband got a huge windfall in this case, which we believe was not fair or equitable. And to do nothing in a case like this is substantially unjust, which is what the cases talk about. I will spare you the facts unless you have any questions. But suffice it to say that a long marriage and a pretty big business with a lot of entities, so there's a lot of variations and a lot of facts. Which I think is an indication of why all the regular ways of doing things, or what we want to call traditional methods, are unjust. You all, I was going to say you guys, that's nice. You all have, we believe this court has two ways to do justice in this case. The first way is whether or not the trial court committed an error by finding that the entities at dispute have not been transmuted. We believe that they have for a variety of reasons. The entities at dispute are not the same entities that husband inherited within the first year or two of marriage. The entities have completely morphed. In addition, there's wife's role. Wife played a significant role during it's a 36-year marriage, but 34 years that we're talking about since he inherited the businesses, since husband inherited the business. So during those 34 years, we believe that wife played a substantial role, from anything from sales to clerical to being the face of the company, et cetera.
Did the wife also enjoy the benefit of the income that came into the community?
She did. The estate received, and we don't dispute that, a substantial estate received, the community received a substantial estate. And so husband, we believe, put those profits back into the community. And wife received a salary. There's no doubt about that. But in addition to that role, we believe there were a variety of corporate and legal documents that are significant here. Not only was wife an officer and director of the entities, not only was she on corporation commission documents, not only was she sign liquor licenses, she was identified as a shareholder, which is an owner, in 26 separate minutes, shareholder meeting minutes, which we believe is significant, and we believe the trial court ignored or discounted, shall we say.
Counsel, let me ask you about those designations. Was it your client's position that she held stock in those entities, or that she had an equitable interest in those entities, or both?
We don't believe in this case, in this type of business, that the stock itself was dispositive. There were times that there were stock, and there were times that there wasn't stock. The quote stock records were, according to 2 to 3 experts, were a mess and not dispositive. So we believe in the totality of circumstances. She did receive some stock for the purpose of, quote, gifting in 1992, but she didn't retain that. But not all of these entities had stock that can be traced back, and in fact, husband's argument about one of the, that he later called a community entity, was the stock was issued in a different name. I mean, the stock is just not dispositive.
Thank you for that, because it did seem to me that was mentioned, but I didn't see it as dispositive. Let me ask you then a related question. There was some pretrial motion practice that, at least from an interested observer from the record, appears that summary judgment perhaps was granted on certain things, but then it seems like those same things were subject to trial as well, and I struggle with that and would appreciate your thoughts on that.
And yes, that's true, and I can't exactly tell you why the trial court allowed us to present some of that evidence. I would guess.
Was there any evidence that you were not allowed to present that you think would have established an ownership interest in the company?
I think that there was a lot of evidence, quote, missing, but no, nothing. There was never a ruling saying that you can't repeat something or that you can't argue something.
But if that's the case, I'm reading the minute entry as saying, after carefully considering the evidence presented at trial, and the court further continues to find that these assets remain separate property. Doesn't that sound like it's not just a summary judgment, but now I've also considered the evidence you presented at trial?
I believe the issue of summary judgment, I think, is re-raised by husband in this case, husband's counsel in this case, because the standard here is more favorable. But I think a minute entry that disposes of hundreds of pages of evidence without hearing any testimony until trial, and in one sentence, is sort of a non-issue.
Just so I'm clear, you're saying just the one sentence after the trial?
No, I'm saying after summary judgment.
Okay, but
Sorry.
there isn't the minute entry that I'm referring to. I'm assuming the court's saying after carefully considering the evidence presented at trial, the court further continues to find that that these entities are husband's sole and separate property. Why doesn't that suggest if you weren't precluded, if your client wasn't precluded from presenting whatever evidence she had, why isn't it now simply a trial resolution of whether credibility or considering this was some evidence of ownership, but I've concluded that it's not enough to establish evidence of ownership?
I don't disagree with you. However, we believe that the trial court committed error with that finding, number one. Number two, that the trial court in the alternative should have at least shifted the burden to husband, which it never did, to then prove that once we had proved enough commingling and transmutation, it should have shifted back to husband to prove that the identity of the entities remained sole and separate, and that was never done.
And are you saying commingling, that it's not able to, you're not able to tell which companies went into it? It seems like everything was inherited. How difficult is it to figure out? Are you saying that some community assets went into the formation of it? Were profits used to form something that had been given to the community, then used to form new entities?
All of those things, yes, as far as we can tell. So originally, in 1984, 1985, husband originally inherited 4 entities. What's at dispute now are 2 different entities. One, which is was renamed in 1991, and husband never had to prove that it was the same entity. And the second one is a completely different entity, which husband would like to refer to as a, quote, holding company, which contains not only a brand-new entity that was created in 1992, some 10-plus years, or almost 10 years after marriage, no, 10 years after marriage.
Created after marriage, were they created with his sole and separate funds, is my question. Were they from his inheritance?
We don't know.
So wouldn't you have to first establish enough evidence of transmutation before that burden shifted to husband to prove it was a sole and separate property?
And we believe that we did.
And the trial court disagreed with you, would you agree?
That's why I'm here trying to tap
Are you
dance through
asking us
this.
to reweigh that evidence?
I mean, yes and no. We believe that the standard of review is de novo, and that we get to argue that the judge discounted these various pieces of evidence that support the transmutation.
What's your best evidence of transmutation?
That's an interesting question. I guess it depends on who the audience is. For me, it was the 26 separate shareholder meeting minutes that identified wife as a shareholder, that everybody seemed to throw their hands up, including the trial court, seemed to throw their hands up and say, my expert reviewed that. They chose not to.
Didn't wife's own expert say there's not a, she's not a record shareholder, she's just a beneficial owner?
Yes.
And a beneficial owner of what, of half of the company?
Of the entities.
So
Of the entities. And
50%?
I'm sorry, I didn't.
No, go ahead.
No, you win. And he was never cross-examined. I think the fact that she was a beneficial owner is another piece of evidence of the transmutation argument.
Wasn't there at least evidence, the fact that to convey shares to the couple's children, the shares were given to mother to then give to the children, would be inconsistent with her already owning half? Wouldn't that be some controverting evidence?
That's a really good question that was never asked at trial of any of the parties.
But that evidence was before the court, was aware of that.
It's not, yes, but the gifting argument wasn't dispositive also of anything, at least according to the minute entry from the court.
But her husband also presented evidence that it was just a mistake. Any references to wife as a shareholder were drafted by someone. It wasn't the case, and it's inconsistent with the actual shareholder documents. So isn't that evidence from which the court could conclude that no, there might be an equitable interest, somehow equitable lien or something? I'm not sure, but.
I think one of the things that you just said was really interesting, and if you want me to go to the equitable argument and the valuation in Ruschenberg, I can, but you said that she wasn't identified as, I'm sorry, and I could be misstating it, but you said something along the lines of she wasn't identified as a shareholder in any records. There weren't any, quote, shareholder records other than those shareholder records that we discovered, that weren't turned over, that we discovered that identified her. So there wasn't a corporate document that said this is the owner of the businesses, this is the owner of Nackard Legacy, this is the owner of Jewel Trucking, and that everybody signed off on. I would guess that one of the reasons why they, quote, restructured, which is an alteration to me and changes the identity, but one of the reasons why they, quote, restructured and created Nackard Legacy was in an effort to make it clear, maybe, if this ever happened, that wife wasn't an owner, but she didn't sign off on that. So again, I think the burden shifts.
If we take this to a less complex kind of thing, if husband owned a house as a sole and separate property prior to the marriage and never transferred title or included wife in that title document, it wouldn't change the nature of it being his separate property. So how, you keep talking about transmutation. There were 26 separate minutes of corporate shareholders meetings. Okay. And I believe your client drafted those minutes.
No.
Okay, tell me.
That was one of husband's guesses, but there was absolutely no evidence of it. Again, husband was not a reliable witness, and I think the minute entry is pretty clear. Maybe that's, my bias in it. He argued whatever he argued. He didn't know how that came
What
about.
was the wife's argument as to who drafted?
Her best guess was that it was some earlier lawyers who are no longer with us. More ways than one. But going back to your house argument, that's where the community lien and apportionment come in.
But a community lien only comes up if the community contributes some funds that increase the value of the property. And that's very different than creating just I'm now on the deed, I'm an actual owner of the house.
I see the Cockrell-Ruschenberg issues as a community lien apportionment issue.
But wasn't that resolved? That's kind of a separate issue. They said they didn't really go up more than the rate of inflation. Isn't that a different issue?
You're right that Cockrell and Ruschenberg don't help us in this case, apportionment. It helps us in this case, and why it's important is because those methodologies and those apportionment methodologies in those cases are not applicable when you have a long-term marriage and turn out to be substantially unfair. And the cases talk about finding a different, quote, yardstick, end quote. So the main cases, Cockrell, Ruschenberg, Roden, and Rowe, are all very short marriages. The longest was Rowe, and it's 7.5 years. Once you apply that reasonable rate of return or compounding, and you have a long marriage, mathematically, you get almost, I was going to say bupkis, you get very little to nothing, which is what happened in this case.
Why isn't the remedy to seek spousal maintenance in a very large amount? Wouldn't that be an equitable way to deal with a situation like this in a very long marriage?
Because that's not what spousal maintenance is really for. Spousal maintenance isn't to make things equitable. A Ruschenberg or an apportionment evaluation or apportionment methodology is exactly what this is for. We don't have one when it comes to long-term marriages. And so what we're asking this court to do, what we asked the trial court to do and we didn't succeed on, and what we're asking this court to do is to give us a different valuation and a different methodology and a different way of doing justice.
But what's your rule when someone inherits, even they inherit it during the marriage, someone inherits $20 million and it's in a bank account? Are you asking for some sort of rule that says, as a matter of equity, the non-inheriting spouse deserves a portion of that?
It depends on the circumstances. If that $20 million stays $20 million and is not increased, then there's no apportionment. If it's increased through community efforts versus passive factors, just, the economy and the rate of growth and things like that. But if it's increased because, let's say it's husband's money, and he's a day trader, and he took that $20 million and grew it into $40 million, then of course you have a claim. Or the community has a claim.
On the $20 million that's clearly an inheritance?
Well, it depends on how you apportion it, but no, that $20 million is preserved, and the passive growth on that $20 million is preserved from the cases.
So it's the labor, if you can attribute that.
Correct.
But here, they're businesses, all the profits are being distributed, husband and wife are getting a salary. It seems, that seems to attribute the earnings from labor that seems different than this was an inherited business that still remains an incorrect.
So Ruschenberg talks about, and Ruschenberg was more about whether or not, or a lot about, and again, Mr. Pollitt's better at Ruschenberg than I am, was more about profits versus increase in value. Here, we're talking about the increase in value, and the increase in value in this case is at least $20 million. Husband walked away with a windfall of $20 million, 10 which is his, and 10 which they gifted to the children. That wife has no offset whatsoever. And all those cases, all those apportionment cases talk about doing substantial equity and justice in creating a methodology. The reason why Ruschenberg came about is because the Cockrell methods weren't fair in that case. Thank you.
Thank you. And we'll preserve 12 seconds for...
Well, I was going to say, and I forgot attorney speak, so I'll take that 12 seconds.
Okay.
Presiding Judge Campbell, Chief Judge Catani, Judge Thema, counsel. Jeffrey Pollitt on behalf of petitioner Patrick Nackard, who is watching, along with my partners Lindsay Cohen and Jenica McCusick, and my co-counsel Keith Berkshire and Erica Levitt. Ms. Nackard, may it please the court. This panel is very familiar with Cockrell and Ruschenberg issues. In fact, Potoff and Roe issues. You've had a lot of recent decisions in the last couple of years involving those, so I know you're familiar with it. In fact, just less than 3 weeks ago, Judge Campbell, Judge Thema, and the Honorable Judge Winthrop issued the Larchick opinion, which caused some reverberations in the family law bench bar, which is fine. But Ruschenberg, Cockrell, and the related cases were all discussed there. In this case, we have Judge Bacchus, who issued a very detailed, unusual in our field, 26-page ruling. There's not a single grammatical error in her ruling. I think she knew this was going to be taken up. So she was very, very careful. She was extremely thorough and identified her task perfectly. She had to decide, was the nature of this company, these companies, transmuted by agreement of the parties or operation of law. And she had to decide the Ruschenberg and Cockrell issues. Was there an increase in value? Were there excess profits? Was there reasonable compensation throughout this long marriage? Any of that needs to be apportioned. Now, we presented this to the court at the MSJ stage with uncontroverted facts, and the judge noted that in the ruling. They were uncontroverted. We prevailed on the nature of the businesses. We conceded on the nature of 2 or 3 businesses that were community, and the rest were separate. When we got to trial and the pretrial stage, it became evident that Ms. Nackard intended to re-argue the MSJ, the characterization issue. She had an expert that we objected to more than once, had an expert report, professor of law from Arizona State, telling the court what the law is. We didn't think that was appropriate. He also filed a supplemental report to which we objected. And he testified over our objection. And we repeatedly objected to re-arguing the MSJ stage. And the judge repeatedly overruled our objection. Yes, ma'am.
Can I stop you right there? So, you were granted summary judgment, and then all of the issues from that summary judgment were relitigated at trial. Is that your understanding of what happened as well?
Yes, ma'am.
And so, would it be fair to say we could disregard the summary judgment and just take up what happened at the end of trial?
From a standard review perspective, yes, ma'am.
Okay.
I think you have to grant the trial court great deference in its findings.
If there had been evidence of shareholder minutes identifying wife as being a shareholder, would that have been a basis for denying
Denying our motion?
Yes.
No, sir. Because under the law, Titles 10 and 29, which establish how one becomes a member or a shareholder in a corporation in Arizona, references in minutes are not sufficient. And you were right, Judge, when you mentioned that of the 26 references, keep in mind there were 26 references in minutes from about 1987 to about 1992. 92 was the last time any were mentioned. 12 of those, wife was the secretary of the corporation. And I've got the exhibits 6 through 13 and Bates numbers if the court would like them, but I have all those specific references where she was the secretary. But that's not dispositive. It's similar to the Roe case.
Counsel, let me ask you, I understand your point that it's not dispositive, but is it indicia of ownership? Yeah, I apologize. Is it indicia of ownership being listed as a shareholder in corporate minutes? Isn't that a little whisper of evidence that the person is an owner? Or are you saying it's completely irrelevant?
It's completely irrelevant, I'm saying. Even being a member of the board could be an indicia in some cases.
And I get board membership and officer is different than ownership, but if you have corporate minutes saying someone is a shareholder, isn't that at least just a smidgen of an indication that they are?
No, sir. Who wrote the minutes?
I assume they were approved by the board.
I beg your pardon?
I assume they're approved by the board. I don't know that I care who wrote them.
Well, and husband and wife were the board. This is a small family
Sure.
company. So
If they're draft minutes that were never approved by the entity, fair enough, but if they are approved by the entity, that is a corporate document, right? You keep that for a whole bunch of really good reasons, right? The corporate minutes, they evidence that the board is meeting and active and other things, and isn't the substance of those minutes as approved at least a little bit of evidence that they're true?
no, sir. No, sir. There may be evidence that someone believed it or someone made a mistake.
What if husband had drafted the minutes and listed wife as a shareholder? And we're suggesting that he presumably approved them. So let's just say it's undisputed that husband drafted the minutes. Would you agree that there's at least a whisper of there's some evidence showing ownership?
On which to hang a hook of ownership?
Yes.
No, sir. No, sir. Same as in Roe. Patricia Roe, in the Roe case, and now that was a similar case where the company was incorporated 6 months after the date of marriage, and Patricia Roe was a board member and an officer, and the opinion referenced records and documents that she presented to the trial court that showed indicia of ownership. It did not identify what those documents were.
But it's very different. Here it says a shareholder. It's different. I completely understand. President, employee, member of the board of directors, that's not indicia of ownership. But in this case where if it says, assuming husband drafted a document that says wife is a shareholder, it seems to me that would be an indicia at least. Maybe it's rebutted by a slew of other evidence.
It is rebutted by a slew of other evidence, if you will, Your Honor. As the court mentioned earlier, the 1992 transfer to wife of 72 shares, basically 1/4 of the company so that they could gift that to the children. That's one indicia. The biggest indicia is in 2014, husband, on his own volition, decided to help the marriage, because the marriage apparently was in trouble by his testimony. He intended to gift to wife half of his interest in the company. And he had it drafted up by a lawyer. And he presented it to wife. Well, if he had the slightest belief that she was not a shareholder, he would not have done that. If he had the slightest belief she was not a shareholder, but should have been because it was referenced in the shareholder minute and the corporate minutes, he would have changed the K-1s.
Doesn't that, some of what you argue, though, assumes that shareholder means exclusive shareholder? I mean, I could be a shareholder of IBM, and I can't speak for the entity, right, because I would have such a small amount. So the fact that that was prepared, shifting half of the ownership, does that really show she wasn't a shareholder?
Yes, sir.
Help me understand that. Help me understand that. If she owned 1%, she is a shareholder, and having someone prepare documents to transfer 50% doesn't mean she doesn't own 1%.
Oh, I agree with that. Those aren't our facts, but I agree with that.
I completely agree they're not the facts here. But
Right.
I thought I heard you say that husband, by preparing that transfer document, that meant she wasn't a shareholder, and I didn't follow that.
Because nowhere in the transfer document does it say, I'm going to transfer you the balance to make you a 50% owner. I'm going to recognize this, whatever percent you have, because it's never been quantified, It just referred to her as errantly referred to her as a shareholder. His gift document does not say, in addition to that, and here's what would lead to make you a 50% owner.
I understand.
Yes, ma'am.
So we have the minutes, and it could have created a fact issue for the motion for summary judgment. Just accept that. Was that issue dispositively decided during the trial on the merits?
Yes, ma'am.
So even if it raised a fact issue, you believe that the evidence was considered by the court, as is evidenced by the court's minute entry that I continue to believe?
Thank you. It is.
Okay, I just wanted to make sure I wasn't missing something.
And I was, I was saying, in hindsight, we appreciate that the court did allow all of that evidence in again. We appreciate that the court did let Ms. Nackard present her case anew, de novo, if you will. And it was over 2 days. So it was a thorough examination. And the court came up with the same conclusion. And as to the Cockrell and Ruschenberg, yeah, I'm responsible for Ruschenberg. I lost that case all the way. But now I know a couple things about it. And one thing I do know about it is Frank Pankow, wife's expert in this case, was my expert in Ruschenberg. Frank Pankow and Linton Kotzen, our expert in this case, are two of the finest valuation experts in the state who know Ruschenberg as well as anyone else in this state. Cockrell in Ruschenberg reaffirms. Well, Cockrell says, we're going to grant the community some interest. We're going to recognize, they call the community an equity partner. We're going to grant the community some interest in a set property business. However, being mindful that the character of that business is not going to change. And the way they laid it out were non-exclusive manners. This court, Judge Bacchus, used one of the specifically delineated methods in Cockrell and Ruschenberg, the reasonable rate of return. She could have used any other method and the answer would have been the same. The reason it's the same is, in this case, Mr. Nackard, when he inherited all of the property in 1984, we had a very unusual event. We had a valuation done for estate tax planning purposes. So in 12/31/84, we have a valuation. That's really unusual in these kind of cases. It was done by Coopers and Lybrand, so it was respectable. However, it was estate planning evaluation, so it's going to be as low as possible. Nevertheless, starting from a low point, you carry it out all the way. We had a C corporation. The reason that's interesting is because in a C corporation, it benefits the owners to distribute as much of the profits as possible in the form of wages and bonuses. That way it's not double taxed. That was done in this case. The reason we have each party got about $6 million in assets. The reason we have that, and we had such a lavish lifestyle, was because they took all the profits. The reorganization was simply to make it a flow through an S corporation. If, instead of taking all those profits, Mr. Nackard had instead invested back into his set property business, taken all the funds and the bounty of his community toil and effort and put it back into his business value would have grown tremendously. It didn't grow, even at the rate of inflation in northern Arizona, because they took all that money out, and that's what they're sharing now. So contrary to what counsel says, it's almost a perfect resolution. It's almost a perfect methodology. If it's a long marriage and you take all the money out, it is equitable that that's enough. If it's a long marriage and you don't take all the money out, these apportionment methods under Cockrell and Ruschenberg satisfy and solve that and recompense the community. And Judge, you are right. This is $10,000 a month spousal maintenance after tax, there's no tax on it, for life. She also testified that she'd have about $125,000 a year in income from the investment assets that she'll have. Plus you'll have Social Security. So this is not a terribly unfair result when you look at what Ms. Nackard is walking away with, and the fact that half of these companies went to the party's 2 children. And that's noteworthy. So we believe that the standard that should be looked at is give the trial court all the deference. There's no There's nothing erroneous about her findings. She was very, very deliberate. Even frankly, if it was looked at under a motion for summary judgment standard, de novo. Well, you're not going to change 25213. This is his set property. There's no question about that. You're not going to change Potoff and Moreland, even Cooper, because these are distinguishable, identifiable assets. It's not like money. It's very similar to Potoff. Black acre and white acre does not yield gray acre. So the trial court got it right. We'd ask the court to affirm, unless the court has any other questions. Thank you, Your Honor.
Thank you.
Can I use my 12
You
seconds to talk
can
really
use your
fast?
12 seconds.
Mr. Pollitt ended up by saying they are easily identifiable assets. They are not. After 34 years, they have altered. The shareholder meeting minutes were signed by husband, number one. Number two, the 1992 gift was 72 shares of one entity. There's several entities. And Mr. Pollitt talked about carrying it all the way through, which talks about, or is a nice way of saying compounded reasonable rate, and I'll stop. Thank you.
Thank you. I thank you both for your arguments. We will take this matter under advisement and issue a written ruling in due course. We are at recess. Thank you.